Okay, so while we are getting the presentation up, let me just do a brief intro. In the July 2021 edition of our newsletter, I published an article titled Remembering Justice Gomery. The article was about a case out of Montreal, Quebec in 1991, 32 years ago, that remains fresh today. And the takeaways from that case and the findings in that case basically define our law today, and the fact that things haven't settled down into a consistent legal picture is a shame, because we have the benefit of that sort of insight from that time. One of the significant background stories to that case, which goes by its acronym PSM versus the father's initials, is that PSM stands for Pamela Stewart Mills, who after this case remarried, moved to Texas, and started the Rachel House, which was the first reunification therapy program that... okay, perfect. Thank you very much. First reunification therapy program in North America. So, okay, perfect. So here we are 32 years later, and there's some quotes from the late Justice Gomery in the PSM case that should define all future disputes. So I would urge everyone to go to the PSG website, where all of the newsletters are archived, pull up July 2021 and read that case, and you'll see the vision that if we can just take the teachings from that one case and apply it in all cases, we'll be that much further ahead. Okay, so I'm going to see. Okay, so this doesn't seem to be advancing it, but we'll use this. Okay, so this is a very large slide deck. It was built for a presentation that I gave in Florida last December for a gathering that Mark was able to put together for me. So I'm really going to do just the front part of this presentation. Everybody will have the deeper thought and background. I wanted to start off with how a PA case usually manifests itself, the various stages, and what we should be doing at each stage. So stage one is a conflictual family system that is not settling down into a healthy state voluntarily. It needs structure. The structure is found either through an agreed parenting plan or an initial court order. If you don't have that, then one parent is going to just, through control of the children, dictate the other parent's parenting time. Now, the unfortunate aspect of our family laws, and this is something that the International Council for Shared Parenting is working on, is that in the initial period between a separation and that first court order, there is no structure. And one parent may very well be dictating the other parent's time. It can take some time at the early stages of a case to get that first contested court order. And by that time, some of the pathological alliances and difficult relational dynamics may have taken root already. We all know that most of the PA dynamics even take place while the family is still intact. And when it separates, a lot of these alliances and power dynamics are already in place. So it highlights right from the outset of any case that delay is the enemy. You need to keep things moving along and not let homeostasis take over a conflictual family situation. Now, along the way of the litigation process, you're going to be fighting narratives. They may be false, they may be exaggerated, they may be true, but we need to move past them. The favored parent and kids will anchor on those narratives. The narratives give them power. So you're contesting not just the people on the other end of the dynamic, you're fighting the narratives. And if you can successfully deal with the narratives, you will disempower the favored parent and the children who act extremely overempowered. So focus as much, sometimes if not more, on the narratives. Remove the narratives, restores the power balance in the family system, because people who are standing in the way of healthy relations don't have anything to hide behind anymore. Part of dealing with the narratives is to shine up the targeted parent. There is no such thing as a perfect parent. The favored parents consider themselves perfect. The children consider the favored parent perfect. That's one of our diagnostic criteria. It's just not like that in life. That's splitting, black and white thinking, lack of critical thinking skills. Again, all the hallmarks of a PA case and part of the diagnostic criteria. So if you're acting for or assisting the targeted parent, there's much that parent can do to tackle the narratives, to regain or gain the confidence of the court, the confidence of the evaluators, the confidence of the therapist. We usually find that the targeted parent will do anything, is a very eager customer, is looking for tools, is looking for solutions. Give me something to do so that I feel empowered, that I can be part of my own solution. And conversely, the favored parent and the children, they're just anchoring on their narratives, and we don't have to change, and we don't have to budge. So in working with and for the targeted parent, I've listed some of the tools. Hire a parenting coach for state-of-the-art parenting. Have supportive therapy for whatever. Firstly, the process itself is extremely disconcerting, and no parent is prepared for the feelings you're going to be enduring and the frustration you're going to be enduring during the process. I often invoke rhetoric from the movies when I speak and even in court. So something that just comes to mind is a scene from the second Terminator movie where Sarah Connor is carving a message into the picnic table. And it's very similar to the message that in the first Terminator movie is brought back in time for her from her future son. There is no fate but that which we make for ourselves. The future is not set. So, anger management, co-parenting courses, books. I have a 250 book parenting library. Self-improvement. All of this is going to really help you because you're faced with a dynamic that is far beyond what a typical parent faces. No parent is trained for what you have to go through as a targeted parent. So you need to up your parenting game. Acting for a targeted parent who exhibits this sort of dedication to self-improvement, to tackling narratives. I've been accused of having a short temper, so I'm going out there and I'm going to deal with that. I don't agree, but I'm going to do it anyway to win everybody's confidence. And maybe I'm not the best evaluator of myself, so in case I'm missing it, I'm going to do that as well. I'm going to learn the techniques to avoid triggers, to self-regulate, to calm myself. And then deploying that when given the opportunity to parent, the kids should notice the difference. If the kids don't, if, as a later slide will show, for those of you, I'll wait, there is a beautiful graphic, the arcade game of whack-a-mole. So you address this complaint, and then you address this complaint, but there's no reciprocal change in the children's behavior. That's not natural. That's not healthy. That's not how relationships are supposed to work. And that plays into yet another diagnostic criteria. Evidence of maladaptive behaviors in the children that cannot be caused by the targeted parent, because what we're talking about is, hey, your mom, your dad met you halfway. You had complaints about this, that. They adjusted the bedtime. They brought in, they did an expansion to the house. You have your own room now. They did this, that, and yet your behavior remains unappreciative, unacknowledging, and as abhorrent as ever. That's not the targeted parent's problem. That's the children's problem, and that's the favored parent's problem, as we'll see in point 4 here. You're going to, in the typical case, want to get directive therapy, so not your typical therapeutic models anchored on the therapeutic alliance, where we don't push people out of their comfort zone and it's all about making people feel good and that sort of thing. This is a family systemic problem, and the process, while we lack a specific term, sometimes reunification therapy, family therapy, the label doesn't matter. It's the nature of the process and the expectations that all members of the family system will make the changes that the interventionist is asking them to make for the greater good of family peace, harmony, and health, and normalizing relations. Inherent in that process will be a mini-evaluative process. What are the presenting issues? What are the presenting narratives? Why the homeostasis? And tackling those, it's like you're doing a mini forensic within the family system. The other benefit compared to a forensic is that a therapeutic intervention is a dynamic process. The person who ultimately is going to give evidence about this family system has been able to perform all these mini science experiments. We did this and that, we built some confidence. I said, the kids, you're now going with mom for lunch and a movie, or lunch and shopping. Then you guys are going to report back to me about how well that went. Dad, you're going to be supporting that fully. A custody evaluator can't do that, can't make demands and then regroup and ask the family to do something else or do it better. It's more of a hands-off, retrospective sort of analysis. So the dynamic process yields much more insight. So I'm coming back in this point 4C to our narratives again. We fight the narratives as much as we are fighting the problematic human behavior. So when we identify the narratives, almost invariably, the therapist is saying to the favored parent, with respect to issue A, I need you to reframe that. You haven't been doing this. it's not as bad as you make it out, or everyone's going to differ about whether, to what extent it happened, or yes, it happened, but it's in the past. Stop anchoring on something from 5 years ago. The kids had a good relationship with their mother well after that. I need you to reframe it. The children are exhibiting unempathetic, stuck behavior, not consistent with a healthy family system that has hierarchies and boundaries. Now, the nice thing about the Canadian case law is we actually have jurisprudence recognizing all of this, as you'll see in a sec. A lot of psychological and therapeutic knowledge built into our jurisprudence. We then, in point 4D, want to see people deploying and changing and moving toward that healthier family system that we can visualize short of a trial. If they don't make it, if the therapeutic process does not meet its objectives within a reasonable period of time, most mental health or the helping professions standards of practice require that person to declare an impasse and cease to provide services that are proving not to be effective, and refer the family, often with a report on the failed therapy, to court for other supportive orders. They may come back with some of the specific directions to supplement the therapeutic referral in the first place, like I mentioned in the expert cross-examination, or the therapist may say, I've worked with this family for a year, I've tried everything that's out there under the evidence-based literature, this family system will not heal. I do not recommend further conventional therapy. The court needs to hear evidence and make some sort of structural intervention in this family system. Don't look to me or others like me for the answer for this family. And that's unfortunate, but at least clarifying for the court, because it narrows the range of options, and you're heading toward a trial, although in Canada we can get some fairly significant structural remedies in a family system short of a trial. You can imagine the hurdles, and the case has to be really compelling, but we can get it even short of a trial. So what are the court procedures then that often are taking place in parallel with the therapeutic intervention? We bring what's called compliance motions, so it doesn't have the quasi-criminal element of a contempt proceeding. I don't have to prove the non-compliance beyond a reasonable doubt. And the way our laws evolved, I can pretty well get the same sorts of remedies as I could in a contempt proceeding. So I have several cases now where it's $1,000 per missed visit. And yes, monetary remedies impact on human behavior. If it still doesn't heal, despite judicial admonitions and other guidance from the court, you're probably heading to a trial. You may try the one last fine. It's likely contraindicated, but let's see what another very experienced family systemic therapist might say. Will they take on this family or not? And often when they see this and interview the prior therapist, they will indicate in what's called a clinical intake consultation that the family likely does not qualify. So that would then bring you to what the court is going to face at the trial. And again, I'm almost out of time. I just want to give you a sense in 57 slides of a lot of resources there. But at the trial, what's the court left with? We have something called the Stark dilemma, which is you can either leave it alone and hope it's going to change, refer them back for more therapy. You can increase the parenting time split to 50-50 to send a message to the kids that they have two parents who can make solid contributions to their life. But of course, these cases are often highlighted by the lack of compliance with court orders in the first place. You can give up, but then that condemns the children to the solid social science of the massive emotional and psychological damage that accrues in young adulthood from losing a parent in childhood because their parents got separated. And you have to bring that science in to the analysis. The only thing that's left, the very, very thin range of options available to the court, is a temporary protective separation. And the case law and the science on these temporary protective separations shows that they work. And we have an increasing body of jurisprudence of the review proceeding on the back end, where everybody's done the work and everybody comes back together and the court has to assess the resilience of the children, and it's reported to the court that there's been this remarkable recovery. So we have an increasing body of these review decisions that prove that protective separations work. So I'm going to wrap up now with this slide. So, like speaker after speaker saying, why do we continue to debate, and Andrew's one of them, PA, our law goes so far as to say you don't need an expert. Judges can take judicial notice of PA and of its harm. But if you want an actual definition, and you'll need the slide deck for this, I resuscitated this advice from a Manitoba psychologist from a 2011 case and finally got it revived. So Ontario cases starting to pick up on this, and it started a snowball rolling down the hill, and there's tons of cases now that adopt this definition. And in the panel that Virginia and I are going to do later on today on denialism, there is nothing that the social media zealots and the other people in the denier community can do to touch this definition of PA. It's untouchable. None of their arguments work, and it's recognizing something that is just the human condition. Going back to the case law of the early 1800s, through Albert Einstein in the early 1900s, who complained bitterly about being alienated from his children, through the family systems therapists of the 60s and 70s, through Dr. Gardner, to all of the experts who we've had the benefit of through PASG, through all the case law around the world. Here you go. This definition is untouchable. Thank you very much.